Let's see here. Why am I? All right, everybody. Hopefully you can hear me and see me. All right, sounds good, Teresa. All right, so let's get started. Oh, let me hold on. I don't want you to have to hear echo. Okay. Let's see here. No, let's go back to that. All right. Of course, everything that I say is my opinion and my opinion alone. So today we're going to go over Owens' request for findings of facts, conclusion of law, and proposed findings. This is something that Gingras filed. I'm not going to go over the pretrial thing until it actually hits the courts. Then I will go over it. So here we have, and it's a little hard to read, but it is from David Gingras, Maricopa County, Superior Court, State of Arizona, request for findings of facts and conclusions of law and proposed findings assigned to the Honorable Julie Matta and in the matters of Owens v. Echard. Titanium. It's only on the Oh. So it says, pursuant to Rule 82A1, Arizona Family Law, petitioner Laura Owens, Laura or petitioner hereby requests findings of facts and conclusions of law with respect to all issues submitted for decision in this matter, including but not limited to any issues resolved at evidentiary hearings set for June 10th, 2024. Owens submits proposed findings below. It will be interesting to see what she proposes because I don't buy a single thing that she says. But let's see. We'll give her credit where credit's due. And will the judge agree with any of this? So, A, proposed findings of facts. 1. Laura Owens and respondent Clayton Echard, Clayton or respondent, first met on May 1st, question mark? What? May 17th. That's when Laura sent Clayton a message on LinkedIn and asked Clayton if he could help her locate some investment properties in Scottsdale. So May 17th and then May 20th, well, you know. 2, Clayton, who is a realtor, responded and told Laura he would be glad to help, as a nice realtor would with somebody who is interested in investment properties. 3, May 18th through the 20th, Clayton and Laura viewed some properties in Scottsdale. On the evening of May 20th, 2023, Clayton invited Laura over to his home in Scottsdale, which she accepted. Okay, so far we're good. After Laura arrived, Clayton told her he was high on cannabis gummies and he offered one to her, which she accepted. All right, so they both took a gummy. 6, during the late evening of May 20th, 2023, and early morning of May 21st, both parties agreed that certain sexual activity occurred between Clayton and Laura, including oral sex. I don't know if it's including, but there was oral. So, okay, still good. Number 7, Laura claims she told Clayton she did not want to have sexual intercourse, but that Clayton stuck it in briefly despite her statement. 8, Clayton denies the allegation. Yep, that's what has been alleged. Clayton says nope. He said she didn't want to do it, so he didn't do it. And I tend to believe that because here she is, 7, 8 months later now. She's just now like, oh yeah, he arped me. Like, no, you would have said that in the order of protection hearing with the judge. That would have been the first thing. It wouldn't have been about protecting your unborn babies. It was the fact that he would have done that. And since you didn't bring that up until 7, 8 months later, oh, I was scared. Oh, I was this. I don't want to hear the excuses as to why she didn't do it. Because while most people I would believe and I would be like, you know what, they weren't ready, whatever. But she had her day in court to disclose this. Now the case isn't going her way, so she wants to add an extra layer onto it and be dramatic. 9, Laura's expert, Dr. Michael Medchill, a retired OBGYN with over 30 years experience, testified that pregnancy is entirely possible even without sexual intercourse. We can find that as a fact because in Dr. Medchill's report, he stated that. 10, the court finds that Dr. Medchill's testimony credible and helpful. No. But it's not Medchill's fault that it's not credible. He was going off the information he was given, which wasn't everything. So we're left with what it is. I mean, could somebody in a far, far away land with different circumstances who are not Owens maybe have certain circumstances? Yeah. But they're not out there committing forgery, false impression, fraud, all that multiple times over a decade. So I don't know if it's credible or helpful because he doesn't have all the information. The court further finds, as a matter of medical fact, pregnancy can occur even without sexual intercourse as long as a male sperm and a female egg are in sufficient proximity to result in fertilization. I don't know if the judge is going to agree with that. I guess she could take the doctor's word that, yeah, it can. And I guess his Virgin Mary patient that he had at Christmas time, maybe she'll be like, okay, yeah, that's what Dr. Medchill finds. Not necessarily what I believe, but that's what he says. 11, for the purposes of this case and based on the evidence presented, it is not necessary for the court to determine whether sexual intercourse did or did not occur between Laura and Clayton. No, I think it's very relevant. I think it is so relevant because she brought up the Aring claims. So let's just swoop that to the side, Judge. Let's not worry about that. Let's just, let's just go with the fact that we don't have to prove whether he did or he didn't. Like, I think it's very relevant because she's speaking on his name about that. I think the judge needs to address it. That's disgusting, Gingras. Let's everybody forget what all these things. And you've been posting clips about, they this and this and this about his deposition, and your client is telling people that she's been AR'd by him and Michael Maricini. No, I think it's very relevant. 12. By Clayton's own admission, the other sexual contact between him and Laura was sufficient to result in pregnancy, even if sexual intercourse never occurred. I don't know that the judge is going to agree with that. Other sexual contact between him. Well, if they're talking about like the naked dry humping, which, okay, do your thing, I guess. But I mean, maybe. I guess that could be other sexual contact. But that still doesn't mean that he stuck it in. 13. On May 24th, 2023, Laura asked Clayton to prepare written purchase offers for 2 properties Laura wanted to purchase in Scottsdale. Okay. This part, I don't know why it really matters. I think, okay, yeah, she had him prepare this. He didn't do it because he told her he wanted to send her to one of his coworkers or his boss or somebody else. Fessed up to being inappropriate with a client. She then called the real estate bar people, and he had to go in and sit for like a disciplinary hearing or whatever and see if they were going to take away his license or not. But I think because he was upfront and honest, and he told his coworker or he told his boss that, hey, this is what happens. This is what I want. Like, I know I overstepped. Like, he manned up. He admitted to his wrongdoings. But I don't know if that really pertains to the case on the pregnancy level. So I really don't know if that's relevant or not. All right, moving on to page 3. Or actually, okay, this is out of order. I don't know why. This is way out of order. All right, well, what we're going to go over is, since it's out of order, that's okay. What are findings of facts and conclusions of law? Findings of facts and conclusions of law explain why the court decided. In other words, if facts were impactful on the court in the areas above, they might denote those facts in the judgment. If the court also finds one of these parties not credible on various points, they might explain why in terms of law. The court might also denote in the judgment what statutes or case law, why it separated that word, they relied on in the decision. It might be that a particular case or statute was impactful regarding why they did what they did. So we will get to figure out why the judge thinks this and which one she relied on, who's more credible, and so forth. Let's see if it actually goes to the correct next slide. Yay, it did. Okay. These 2 were supposed to be at the very beginning. My apologies. Why are findings of facts and conclusions of law important? Findings of facts and conclusions of law are essential. Hello, Casey. Are essential because they give the why behind the court's decision. Many parties want to understand the rationale behind the court's judgment. Yes, I think the parties do, and the public would like to know the rationale behind the court's decision. That's why we like when Judge Matta or any other case that you're covering, when the judge gives their thoughts and puts their words down to say, yeah, I'm denying this, or yeah, I'm approving it, but they say stuff in the meantime to be like, oh, she ain't having none of this BS. Okay. Further, in one or both parties wish to appeal the decision, findings of facts and conclusions of law are essential for appellate review. Without them, it might be hard for an appellate court to find that the trial court abused its discretion or erred as a matter of law. So remember, Gingras is already like, we may not win this in court, but we can win it on appeal because, appeals are so easily won. Um, so this document that he has filed is preparing for the appeal of them losing. So he's already preparing to lose, which you want your lawyer to do, because that's why you make the objections and you do all these things, is so that when you appeal it, you've made a record of things. And if your lawyer doesn't do these things, then they're not zealously advocating for you. And we want a zealous advocate. So it says, to get them, parties often have to request findings of fact and conclusions of law before trial. Otherwise, they may have a hard time appealing the decision. So he's doing this pre-trial, and so it will be good for the appeal process and everything else. Of course, the requirements here can vary by state and locality. Nonetheless, it is vital to request findings of facts and conclusions of law where necessary. So this is just a necessary step that Gingras needs to go through, especially if they are putting all their probability of winning on an appeal. Good luck. I don't think Judge Mata is going to have anything overturned, in my opinion. All right. Now back to the document. So Laura had Clayton, draw up those purchase agreements in Scottsdale. The offer amount was $425,000 for, I think. Oh, this one's for one. I thought there were two. Oh, okay, here he is. And so that one was 425,000, and the other was located at blank in Scottsdale, and the offer amount was 699,000. So that's a big chunk of change that Clayton was like, no, I messed up and don't want to be with this crazy lady. We shouldn't have done this. He was willing to give it all up. So it's not about the money for him at all. Because otherwise he would have just done that, let her on until the sale was complete, and then so forth. But he didn't do that. So good for him. He had a lapse in judgment, but he got back on course. 14, Laura asked Clayton as her realtor to prepare the purchase officer offers and to submit them to the seller or the seller's agent. 15, Clayton prepared the purchase offers, which Laura signed on or around May 24th, but Clayton never submitted them to the seller or the seller's agent. Laura later asked Clayton whether he had heard anything from the seller in response to Laura's offer. Clayton falsely informed Laura that he had submitted the offers to the seller, which he knew was false at the time. And I forget if I've actually seen the message where he actually says this. He shouldn't have said that. Clayton shouldn't have lied to her. But I know at one point he also told her, no, I don't want to be your realtor. I want to give it to somebody else and all that. But she didn't want to hear it. She was like begging him to be her realtor. So there's some confusing stuff there. But if he did say he did it and he didn't, that's bad on Clayton. But again, I don't think that's relevant to the pregnancy story. 18, when asked if he had received any response, Clayton told Laura that he had not, but never told Laura the reason why no response had been received, i.e., because the offers had never been submitted. 19, based on the undisputed evidence, the court finds as a matter of fact that Clayton made two knowingly false statements to Laura about real estate purchase offers, and the false statements were made to Laura before she told Clayton she had tested positive for pregnancy. Okay, sure. We'll find that as a fact. Not relevant to what we're here for. And to me, well, you shouldn't lie, but to me, lying about whether you've submitted a purchase agreement or not, that's not a life-changing lie. I mean, it maybe for the other person, but he told her she could go somewhere else. Take your money somewhere else. I don't want your money. And she's like, no, 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 no. I want to do it with you. I want to do it with you. Because we can be together. We can date. Just enter my dating contract and you can keep my contract on the houses and have the money. And then you can spend it on me to go on dates. Like, it's just all the best. All right. 20. Now we should be getting into the nitty gritty stuff. The court finds, pursuant to Arizona Rules of Evidence 608B, the false statements made by Clayton to Laura are relevant to Clayton's honesty and credibility. Yeah, I don't think the judge is going to find it relevant either. It's like, that's not what we're here for. That's not what the paternity case is about. I mean, the paternity case is to find paternity, whether she was or was not pregnant, and like if she lied about it. And we don't have the child custody or child support and any of that anymore, but we still have that. I don't think the judge cares about real estate. But sure, if you want to put it in there, because he's putting it in there to be like, see, Clayton lies too. Okay, he lied about submitting an offer. Not out there trying to ruin people's lives. Like, she could go get other house. Okay, she lost this real estate. Well, she can go find other real estate. I mean, but he shouldn't have lied. On May 31st, 2023, Laura took a home pregnancy test, which showed a faint result. So we've got, that's the 11-day mark. What he forgot to put in here was she sent a text at 6 days predicting her pregnancy. You forgot that, Gingras. She predicts all of her pregnancies around 6 days and she tests on the 11th. Pretty much in every single case. Okay. 22. On June 1st, 2023, so a day later, Laura went to Banner Urgent Care. Oh, I hate Banner. Like, it's nothing against Banner. But if he says she told him he could look at her patient portal at Banner Health. Look at my patient portal. Look at my patient portal. It shows positive HCG at Banner Health. Banner Health. Ugh, I hate it. Better Health. Apparently, you have an amazing patient portal that's easy to access and understand. So props to Banner Health for that. Sorry you're affiliated with this woman. She went to Banner Health Urgent Care at Greenway and 64th Street. She informed the nurse that she believed she may be pregnant, and she asked for a test to determine whether she was, in fact, pregnant. The test result from Banner Urgent Care was positive for pregnancy. Why are you going to an urgent care for this? Like, I don't know what Banner, or like, are they like some of the other, like, we have some urgent care places here and they have a side that's like urgent emergency type stuff, so you don't have to go to like an emergency room, but then they have a side where you can like see a doctor and you could actually have somebody as like a PCP. So it's like regular stuff where you're not like urgently sick or anything like that. And then they've got the emergency side. So if anybody's been to a Banner Urgent Care, like, do they have that, or are they just straight like an emergency room type thing? Because why are you wasting emergency room type people's time with just a pregnancy test? Like, people are having strokes and you're wasting their time with this. And you have money. Like, go to an actual doctor. Laura testified that for more than 6 months prior to May 2023, she was not sexually active with any other man. Based on this, Laura believed that if she was pregnant, Clayton was the only potential father. Well, that's her word, which, since there's not another guy in this case, I almost tend to believe it that she wasn't like that with anybody. Because every person she's with, she ends up pregnant. There wasn't a pregnancy between Gillespie and Echard that we know of. So, yeah, she probably was. That still doesn't mean that you had intercourse with Clayton. 25. Laura's expert, Dr. Medchill, testified that a home pregnancy test can detect pregnancy 11 days after contraception. Not contraceptive. Conception, 11 days after conception, and that there are no medical basis to conclude that 11 days post-conception was too soon for Laura to determine she was pregnant. There are some tests. I think when we went over first response, I think they are 11 days. Say 11 days. No, my daughter found out when she found out she was like 2.5 weeks along. I don't think she was quite 3 weeks yet. She found out really, really early, but she was panicking as she should have been. Says 26, the court finds Dr. Medchill's testimony credible and helpful. The court further finds, as a matter of fact, a positive pregnancy test 11 days post-conception is medically plausible, and that the duration of this time period is not impossible, short to allow for accurate determination of pregnancy to occur. I think we can agree with that part of Dr. Medchill's report. And in that specific topic, I think he can be helpful and credible. That other part, no. But that's not Medchill's fault. 27. After she received multiple positive pregnancy tests, Laura tried to discuss the situation with Clayton to determine his intentions. He already told you his intentions prior to pregnancy. He doesn't want to be with you. You can discuss the baby, but you don't need to discuss a relationship because he already told you what he felt about a relationship. And babies should not change your views on being with somebody. They just shouldn't. Okay. In response, Clayton was hostile and dismissive. Clayton claimed it was impossible for Laura to be pregnant because we never had sex, despite the fact that Clayton also admitted engaging in other sexual conduct, which was sufficient to create the possibility of pregnancy, as Clayton later admitted. I think he was confused during this time. He was like, okay, like there's no way, or okay, maybe when we were doing that little naked, grindy, dry humping thing, maybe something did, or maybe she did inject herself with a turkey baster, like on, no, it wasn't Jane the Virgin. I forget what show somebody did that with a turkey baster. If anybody knows the show where a girl or something actually does that with the turkey baster, Jane the Virgin's was like a doctor mix-up thing, but the thing does look like a turkey baster. 29. On June 19th, 2023, so almost a month later, Clayton agreed to meet with Laura at his home in Scottsdale to discuss the situation. After Laura arrived at Clayton's home, he presented her with a home pregnancy test he had purchased. Clayton asked Laura to take the test immediately in front of him while he watched. No, he didn't. She went to the bathroom. He didn't watch her pee on this stick. I don't know what their idea of watching is, but if you're not there seeing somebody pee on a stick, you didn't watch them take it. You may have watched them go into the bathroom and watch them come out. But apparently she has stage fright, which I would too if I'm trying to fake pregnancy tests. Like, oh my God, is this one actually going to turn out? Like, I know I have a superpower to make the other ones at home do that, but am I actually, what if this one doesn't? What if this one shows negative? Like, I wonder, like, surely she worried about that. She might not have. Depending on what causes it. Like, um, that test result was also positive for pregnancy. 32. 2 days later, on June 21st, 2023, Clayton sent Laura an email entitled Something to Consider. In this email, Clayton made the following statements, among others. Even after seeing a positive test, I still had doubts in my head. Something was telling me to look deeper into things, so I did and came up with a theory that could potentially be realistic. So that's something Clayton said. He still has doubts in his head, and he went looking deeper for things to see if something could be realistic to make this a possibility. He might have been thinking that, especially when you're like, okay, no, we didn't have sex, but oh crap, this pregnancy test is positive. Like, yeah, that might make you think you've gone crazy and stuff. So I can definitely see why his head was spinning. I'm sure he didn't sleep much that night. All right, page 5. Considering you only performed oral on me and no intercourse occurred, the chances of you being pregnant seem considerably low. Although, again, maybe rubbing up against one another allowed sperm to make its way inside of you, but it's a very low probability nonetheless. It is one. So, he's over here thinking, okay, maybe. Like, I mean, she would be like in the 1% chance of the world that happens because it's like very, very, very low possibilities. 34. Attached to the something to consider email were 2 photos of a home pregnancy test. One photo was labeled day 11, which reflects the test Laura took on May 31st, 2023. And the second was labeled day 21, which referred to the test Laura took in front of Clayton. I'm going to say at Clayton's on June 19th, 2023. So she would have been a month along. She must have had an easy pregnancy because we don't hear about any prenatal symptoms that she's had. We don't hear about morning sickness. We don't hear about anything, her being tired, her boobs hurting, her nothing. No pregnancy symptoms in any of the pregnancies in the last 10 years. Obviously, we know why, but like, come on, if you're going to fake it a little better. In the something to consider emails, Clayton stated, something else I found interesting was that the test you first sent me on day 11 and the test you took on day 21 with me looked identical as far as the line goes. So from my understanding, which I would have to go and look at her, let's see. I have to look, but I think it was in Clayton's deposition that Gingras posted that he said, or she, something within the last week said that second line was faint. It was a very faint line. It wasn't an in your face, you're pregnant line. I don't remember if they ever took a digital one that said not pregnant or pregnant. There's been so much going on in this case. I can't even remember because I don't care about the HCG test all that much. We looked at them in the beginning, but if she ever took one of those that was words and not a plus or minus, or it was digital and not like that kind of faint line, that those would be more interesting to see. So it says, as far as the line goes, it looks similar to the one she took on day 11. Assuming Laura became pregnant on May 20th, 2023, the photo of the test she took on May 31st, 2023 would be accurately be described as day 11, meaning 11 days post-conception. However, the test she took in front of Clayton on June 19th, 2023 would not be accurately described as day 21 because there are 30 days between May 20th and June 19th, not 21 days. Gingras. I'm, I'm going to tell you something, Gingras. While we want to get hello, nothing like tea. If y'all haven't checked out his timeline, y'all should definitely go check it out. He has a great, he or she, I don't know. The Puppers is really cute. They have a really, really good, he has a really good timeline, or she, about the facts of all this dating back to the very, very, very beginning. I've linked it in some of my videos. Okay. Um, she has a great timeline. If you have that timeline and y'all want to check it out, if you want to link it, nothing like tea, please do. It's a great timeline. It helps very much in my series of stories videos when we're going through, like we're doing in the Greg Gillespie case, and we've done with the Michael Maraschini, and we did with Clayton as well. So definitely go check out her timeline. Yes, of course, link it. And so, but as I was saying, um, Gingras. While when we think of pregnancy, yes, we would be like, okay, May 20th to June 20th is 1 month. Um, and then, and so forth. But sometimes with the medical stuff, it'll be off. That's why there's part of the estimated due date. It may be off a little bit because um I a lot of times sometimes in the medical world or pregnancies are done kind of in 30-day increments. And so it's basically every 30 days is a month, every 4 weeks. But Ginger saying, "Oh, there were 31 days." That's not really how it's done. Because basically you count 40 weeks. And if you divide those 40 weeks up, it's in like 4-week instrument or increments. That's why 12 weeks is 3 months. You take 4 weeks and you divide it into the 12 and you get 3 months. So whether or not it is 31 days or 30 days, that's not how pregnancy works. Do a little bit more research. Please go talk to a woman that's been pregnant. Go talk to your ex that tried to say you had a kid with her. Go ask her. She'll know. The stupidity on basic things. Like it just shows that nobody in this case has ever been pregnant. And 40 weeks is technically 10 months. Even though it's supposedly 9 months. It's because the pregnancies prior because you go by the last menstrual cycle. From that to baby's due date is about 40 weeks. So part of that is including actual technical time that you might not actually be pregnant, but you are. It's just so dumb. I am so sorry that you've had miscarriages. And yeah, her insanity is insane. She is definitely evil. And then that's the part that makes me mad is, I've lost a child and it just irks me. This is not something you lie about. But let's see what else he gets wrong because he doesn't know how to do pregnancy math. By Clayton's own admission in the Something to Consider email, Laura presented him with at least 2 positive pregnancy tests in May and June 2023, including one test which was purchased by Clayton and taken by Laura in front of Clayton at Clayton's without any advance notice. Yeah, I like how in the deposition too, they were like, you bought a test and you lured her over and you didn't tell her you were going to make her take a test. Like, that's not predatory. Like, oh, you lured her over there. Did you tell her you were going to have a test? No, but she could have probably guessed he would have made her. Like, oh, the gall. He made her take a pregnancy test. Yeah, she has. She's just another Amber Heard, in my opinion. And no time in the Something to Consider email did Clayton ever suggest Laura had faked these pregnancy tests and done anything to affect their results. Okay, he was probably still researching at this point, still trying to figure out what the hell is going on because none of it made sense in his head. Nothing was more annoying than watching her stand. God, nobody rubs their belly that much. Like, you rub it when, like, you need them to calm down, or like they're in a spot, you may like rub it to push them, or if you're hurting there. But to just insistently rub your belly for 2 hours is insane. Nobody's doing that. Standing up. Good Lord. Make sure we didn't need to see your belly because eventually your belly came up over your boob. So as long as you had your face and your chest in the shot, we would have seen your belly. And then she's like, oh, can I stand up and show him? What have you been doing for 2 hours, woman? The judge was probably like, you've been showing him your belly for this long. Well, what if he didn't notice me? Maybe he didn't notice my belly. Like, it's just, yeah. No, that was so distracting. You could barely focus on anything else because you're like, what the hell is this woman doing? So he didn't accuse her as of this point about the pregnancy being faked at this point or not. Instead, in the Something to Consider email, Clayton presented a theory that Laura may have received false positive test result due to medication she was taking, potentially due to her prior epilepsy diagnosis. So there he is. He's not saying she's faking it at this point, but hey, maybe you aren't actually pregnant. Maybe your meds are causing this to happen. So, like, you need to go and get this checked out because he's thinking that surely she wouldn't lie about this. Surely she wouldn't fake this. But for some reason or another, that test came back positive, and he's trying to figure out how and why. So he at this point is not thinking that she's lying. Like, she's not faking this, but there could be something else. So he wants her to figure out whether it actually is a baby or is it because of her medications. He's not seeing her as pure evil yet at this point. Laura's expert, Dr. Medchill, testified certain medications can produce false positive pregnancy test results. Dr. Medchill further testified as a part of his review of this matter, he requested and received copies of approximately 200 pages of Laura's medical records from Barrow Neurological Institute in Phoenix, all of which were previously disclosed to Clayton's counsel. Great. We have her epilepsy doctor's appointments. Gingras has submitted to the court witness intimidation on the record. What? I'm going to have to go look at that. That's ridiculous. There's no witness intimidation. He's the one intimidating witnesses. Yeah, she could. I mean, she was a songwriter. She could have just wrote songs about this. Yeah, God. I saw like that, but they're like, he's like, no, there's a subpoena for him, so you're not going to be able to arrest him. Well, I didn't see that subpoena, like, because he doesn't ever notice anything. Yeah, he is just a big douche canoe. On the record, he did that. That's just, I don't think that the judge ain't gonna like that. She's not gonna like it at all, because she's already put him on notice for them too, for Greg and Michael and maybe Matt. Like, she's already like, you've been told about these people. You know, you've been told that they are coming to testify. So don't sit here and tell me that you haven't or anything like that. Don't be trying to do any of that. So she's not gonna like that at all. She seems nice enough, but she also seems like a mama that don't deal with BS. Her house is probably in order and her kids probably behave well. 42. Dr. Medchill testified Laura's medical records from Barrow contain summaries of all of Laura's reported medications, and none of those medications would cause a false positive home pregnancy test. 43. Laura testified that on November 14th, 2023, she sought OBGYN services from a facility called MomDoc. Where's October, Gingras? Where's October, where the protection order hearings and stuff were? The order against harassment, her order of protection, her stating she went to Higley and, oh gosh, I don't remember what the other one was. It started with an M. You're missing all of October, Gingras. Like, where is that part of your file? And if you need that part, it's on YouTube. So, and we know you've been watching YouTube. So, why do you not know about anything in October? Dr. McCool. Yeah, that's it. Thank you, Amanda. He just goes from June to November. Like, what? There's a lot of missing stuff here in your fact findings. So she goes to MomDoc on November 14th, 2023 to determine whether she was still pregnant. At that appointment, Laura was given 2 pregnancy tests, both of which were negative. Laura testified that between May and November, she did not change her epilepsy medicine, nor did she begin any new meds or stop taking any medications other than as reported to her doctor at Barrow Neurological Institute. Okay. So maybe it's not your epilepsy medicine. Maybe it's something else. We don't know what it is. But we don't believe it was pregnancy because you've done too much. And it's not hard to prove that you're pregnant. It's not. And this is something girls have to do all the time because guys are like, no, you're lying. Because there are girls out here like this. So they're like, no, you're going to have to prove to me that there's an actual baby. And like, it's so easy to prove to these guys when you're actually pregnant. And she just never could. Laura testified. Okay, so we got that. Based on the evidence presented, the court finds, as a matter of fact, that Laura did not take any medications that could plausibly have caused a false positive pregnancy test in 2023, and that to the extent Clayton has claimed otherwise, he has failed to provide any credible evidence to support that conclusion. I don't think she can. I don't think she can find a fact that Laura didn't take medicine or did take medicine. I don't know that she can factually find Laura or Clayton's word on this because it's just a bunch of hearsay. So there is not technically a fact to find because there's no evidence supporting either one. She can say she didn't, but she says a lot of things. Clayton can suspect it, but he doesn't know because he doesn't know what she's doing or how she's doing it. There are 4 men who are trying to figure out how this keeps happening because it's not because she's pregnant. So I think 45, I don't think that the judge can come to a factual conclusion on that or finding. 46, Laura testified that no time did she do anything whatsoever to tamper with these pregnancy tests or do anything to alter their results. I don't think we can find that as a fact either. Because there's a reason that they kept popping up that way. Like, can you explain the reasoning other than pregnancy? And that's something we'll never know the answer to, I'm sure. Right. 4 men that we're aware of. Girl, every time she opens her legs, she is pregnant with twins in the last 10 years. Results of a genetic test indicate that the likelihood of alleged father paternity is 95% or greater. The alleged father is presumed to be the parent. Well, we don't have that in this case. They don't have any 95%. Child and party opposing the establishment of the alleged father's paternity shall be established by clear and convincing evidence that the alleged father is not. Yeah. There's just nothing that he's not the father because there was no DNA to try to figure out what he would be the father. Yeah, he leaves out a lot of stuff. He's missing a lot of context. So I don't think she can find that she didn't do anything to alter the test. She may have altered the test. She may be on something. Like, we don't know. 47. Laura's expert, Dr. Medshield, testified home pregnancies are generally accepted to be scientifically accurate and reliable indicators of pregnancy. Indicators of pregnancy. Not that it is for sure pregnancy. Yeah, no, she was not told no growing up. Her parents still don't tell her no. Hello, Brady. It's just, they're reliable indicators. Indicators, okay. You can have a lot of indicators. You can have indicators that you have a cold. You can have indicators that you have COVID. And then you go to the doctor and you test negative for COVID or strep. Your throat hurts. You have indicators of that, but it's negative. So whether you have an indication or not, it's just something that could possibly be that. Go get it checked out. Yeah, to keep men. No, she's not keeping any men. Not keeping any men. Not until she changes herself and accepts responsibility and is accountable and go gets therapy and all that, I don't think she's going to be able to keep a man, especially if they do any type of background check on her. So, accurate and reliable indicators of pregnancy with an accuracy rate of 98 to 99% when used as instructed. Well, we hope she used it as instructed, but, well, she didn't take the second pill in the Gillespie case correctly. I don't know how you don't take the second pill, but you took the first pill right. I don't know how you do that. So, I don't know if she took the pregnancy test correctly or not. 48. The court finds Dr. Medchill's testimony credible and helpful. The court further finds, as a matter of fact, home pregnancy tests are generally accepted to be scientifically accurate and reliable indicators of pregnancy with an accuracy rate of 98 to 99% when used. I think we can accept that part of Medchill's report as well, that usually pregnancy tests, 98, 99%, are accurate and reliable indicators of pregnancy. I think common sense people can come to that conclusion. So, all right, we're okay with Medchill's fact on that. Then we've got 49. The court finds that to the extent Clayton claims the two home pregnancy test reference in something to consider email were either faked or, no, we can't trust what she says. I'm talking about the doctor, like Medchill's report and what he can be considered. But no, we can't trust a single word she says. That's why, like, her factual findings are BS, in my opinion. Okay, so in the email, something to consider, emails were either faked or otherwise tampered with in some manner. Clayton has failed to provide any credible evidence to support that conclusion. Okay. So he can't prove it. He has his suspicions, but he can't prove it. Okay. Sure. 50. The court finds as a matter of fact that Laura did not tamper with or otherwise fake either the home pregnancy test she took on May 31st, 2023, or the test she took in front of Clayton, not in front of Clayton, at Clayton's on June 19th, 2023. All right. We'll have a good evening, Dave, and maybe you can catch the end of this later. Let's see. The court further finds as a matter of fact that Laura did not tamper with or otherwise fake the pregnancy test she took at Banner Urgent Care on June 1st, 2023. And that to the extent Clayton has claimed otherwise, he has failed to provide any credible evidence to support that conclusion. Again, she can pop positive on a test. I believe she can do that. Doesn't mean that she didn't mess with the pregnancy or she didn't add something to her pee or whatever. I know Clayton said, like, he took things out of the bathroom. I think he made her go into the bathroom with, like, nothing in her thing, like, so maybe she couldn't take her purse, things like that. But okay, she can pop positive for a pregnancy test. And if somebody tries to say, well, she went to Clayton's and she didn't know she was going to have to take a pregnancy test there, and she ended up still popping positive for pregnancy. If you don't think she knew in her mind that he was going to probably make her take a pregnancy test in front of him, you're kidding. Because she would fully be prepared to go over to Clayton's and take a pregnancy test. Whether she knew about it or not, she had to know something like that was coming. But no, Clayton hasn't been able to say or prove anything about the Banner Health Urgent Care patient portal test. Laura testified that on July 23rd, 2023, she experienced bleeding and passed two small fleshy objects that were much smaller than any hand. He bolded that because on Twitter, he was having his fit that he's saying, oh, Woodnick lied and said it was hand-sized. When no, she said in her deposition, it was smaller than any hand, like smaller than a hand. And I am not going to find a fact that she was bleeding with fleshy objects. There are parts of that picture that looks like it has arts and crafts on it. Clayton provided the test for the one that she took at Clayton's house. He had bought the pregnancy test, and it, I believe, was the same brand, the same exact one that she took at the 11-day mark. Yeah. So, like, if anybody tries to say, well, he had her over there, but he didn't tell her she was going to have to take paternity or pregnancy test. So, if she was lying about it, like, how would she know that she needed to pop positive going over there? Because she's not stupid. She acts stupid, but she's not stupid. She knew Clayton was going to have her take a pregnancy test, more than likely. She went over there making sure everything was going to pop positive if she did have to take a test. Says, believing that she might have miscarried, Laura testified she took photos of objects she passed and sought medical advice from a telehealth provider. I don't know if it was a telehealth provider. It could have been a miscarriage hotline, which is not a telehealth care provider. They told her to go to the doctor. And says, in response to the telehealth provider informed her it was hard to tell whether she had miscarried and that she should continue to monitor the situation and seek further care as needed. If you are bleeding and you are pregnant, you need to go to the emergency room. It happens. What else it could have been? There are ladies that have, and sometimes it'll bleed and then sometimes it won't. But I know that during my daughter's pregnancy, in that like very beginning stages of the pregnancy, it was still within that 12 weeks. She ended up bleeding during that time. What did we do? We went to the doctor to find out, okay, is this the beginning of a miscarriage? Ended up not being that. It ended up being a subchronic hematoma where like the uterus and the placenta is separating. A lot of times the blood will absorb, but sometimes the blood will and can leak out. But had we not gone to the doctor, like, I mean, what does she be like? Oh, like, I would have never told her, well, go take a pregnancy test, see if you're still pregnant, or do that a couple days later. No, she's bleeding. We're going to the doctor. And it wasn't a miscarriage. Thankfully. I have my little grandbaby who's 7 months old today. He's the cutest. 55, 2 days later, on July 25th, 2023, Laura took another home pregnancy test in order to determine whether she was still pregnant. The test was positive. This is not how you determine whether you're still pregnant after bleeding. It's just not. It's nobody in their right mind does this. On August 1st, 2023, Laura took another home pregnancy test that was also positive. Prior to August 1st, 2023, Laura and Clayton had various communications about the situation, but they were not able to reach an agreement on any issue. Yeah, because he doesn't trust her. And she messages people too much. Yeah, these are the lies that Laura will tell for sure. I can't wait to see what next response. Now he's going to skip. Oh, wait. After May 20th, 2023, Laura stopped having her normal menstrual period. Her period did not resume again until November 2023. if you miscarried in July, a normal person, we're going to talk about normal menstrual periods, would have started their periods back up. So for some reason or another, which I do not believe, from May to November, she didn't have any periods. We still don't know when her last menstrual cycle was in May. Like when her May period was, when it ended in May. Whatever her period info is for May, that we don't have that. Because that would help us more determine the date of pregnancy. But she says she didn't bleed again till November. Well, I think July she bled and had a period. That is me. Just 1 second, guys. Sorry, guys. My son came in. All right. So I think she's lying. She's lying about her period. She bled in July. Looked like maybe some blood clots, but also part of that looked photoshopped. The gross part of the thing looked photoshopped on. The other stuff was just maybe normal period stuff. I don't know. It just all looks fake. Between May 20th, 2023 and November 2023, Laura gained weight and experienced significant swelling in her abdomen. You know what we don't call a pregnant belly? A swollen abdomen. You know who calls it that? People with the swollen abdomen issues that she has. We don't say our belly is swole. Our abdomen is swollen. Well, look at my swollen belly. You're like, bitch, you're pregnant. So the fact that it's described as swelling in her abdomen, yeah, no. 60, between May 20th, 2023 and early November 2023, Laura testified she felt like she was pregnant. Okay. I feel like I'm 80 years old. I'm not, but I feel like I am. So does that make it a fact? Can the judge find that as a fact, please? Yeah, she has she has a history for the gluten and the swollen abdomen. You're not describing a pregnant belly as a swollen abdomen. You're just not. 61, Laura filed an established petition on August 1st, 2023. At the time, Laura had reasonable factual basis to believe she might be pregnant and that Clayton may be the father. At the time Laura filed this case, she was not represented by counsel. We know that. I can agree on that statement. At the time he first appeared in this case, Clayton was not represented by counsel. Correct. We can agree on that one. I don't think she can factually find what Laura is stating. I don't think she can find those as facts. I think she can say, okay, I believe that that's what Laura says, but I can't find that those statements are factual. I don't have any evidence to find those as fact. She has no credibility, so I'd be like, nope, lies, lies. 64. In August 2023, Laura asked Clayton to agree to a DNA test to be performed by a company called Rabgen. Clayton initially told Laura he would participate in this test. Yes. On August 15th, 2023, Laura paid the $725 to Rabgen for her DNA test, but Clayton refused to provide a sample for the test. Right, you would. But she claims, I mean, in various points in this case, she claims she's been pregnant twice, 3 times, 4 times. So it's like, all right, 2, 3, 4. She's going to start her dancing one woman show in a 2, 3, 4. So she says Clayton refused to participate in the test. That's not been my understanding of this, but okay. In July and August 2023, Laura made multiple appointments to see an OBGYN named Dr. McCool. She scheduled 4 separate appointments, rescheduled 3 of those, and canceled the final appointment after reporting that she had tested positive for COVID. But there's Dr. McCool's name. When I needed it, it wasn't there. Four appointments. You couldn't go to not one of them. Why? Why couldn't you go to one appointment? One with an actual OBGYN during this time. She knows exactly why she couldn't go. Dr. McCool's office has produced 44 pages of records confirming that Laura contacted the office multiple times, scheduled numerous appointments, and provided the office with other records related to her pregnancy. She provided them with her Banner Health, is what she provided them with. Which doesn't mean anything. They do their own pregnancy test. When she went to Dr. McCool's office, they would have tested her for pregnancy there because it's something that you do in the initial visit anyways. I don't care what Dr. McCool's office has. He never saw her. I don't care that she tried to make appointments. That means nothing. Not relevant. Later, in late September, early October, both Clayton and Laura submitted samples to Ravgen for testing. 71, a representative from Ravgen later informed both parties the initial tests were inconclusive because there was little to no fetal DNA found, and there was insufficient information available for Ravgen to reach a conclusive result that either included or excluded Clayton as the father. I don't think that it was inconclusive. Like, I don't know how many tests it would have taken. Like, would they still be trying to take tests? If she was, well, no, they would have stopped in February, I guess. But would they have still been taking tests all the way to February because there would have kept being little to no fetal DNA? And they'd be like, how many tests does it take to say, okay, there's no fetal DNA here? On October 16th, 2023, Laura had a blood test done which showed an HCG level of 102. Correct. Which, having a level, I'm glad she submitted the correct one over to the court, and she didn't submit the one that she had doctored and sent to Dave Neal, because that would have been even worse. I mean, the public knows about it. I'm sure and I know the judge knows about it too, but she never submitted it to the court. So it's not, that wouldn't be one of those ones that was considered like fraudulently submitted evidence and stuff like that. Like, I mean, was it used to deceive people? Yeah, absolutely. According to the testimony of Dr. Medchill, an HCG level of 102 is strong proof of a pregnancy. But at this stage, it is indicative of a non-viable pregnancy, meaning a pregnancy that was unlikely to result in the birth of a healthy child, or alternatively, a pregnancy that was likely to end with a miscarriage. Okay, wait. Let's go back and see. What was the date on that? October 16th. But they think she miscarried in July. So from July to October, she's still doing that. Now, I did do a little video on my positive HCG test from last year after a hysterectomy that I've had for over a decade, that I had a positive HCG test. My level was nowhere near 102. But I've also posted a picture of my daughter's HCG test that shows what a real one is. All right, nothing like tea. I will see you later. But yeah, it's not viable. I don't see how she lost the child back in July, possibly, but she still has a non-viable pregnancy as of October. Like, we still don't know in their story. They still cannot confirm when she lost the baby. We just know it was somewhere before November when she went to mom doc. According to the testimony of Dr. Medchill, HCG in a woman's blood is typically evidence that a woman is or recently was pregnant. HCG in a woman's blood can also come from other unrelated medical conditions, such as tumors and certain types of medications. But there is no evidence to show that the HCG in Laura's blood was the result from anything other than pregnancy. No, there's not. Because they didn't test it for other things. They didn't go diving into what else could have caused it, because she just went to a lab place. Had she had done this at like Banner Health, Banner Urgent Care, and it would be in her patient portal that she wants to give out to everybody, then she could have gone even back to Banner Health and done the test, done the blood test, HCG test. And then if it would have come back with an HCG level of that, they would have in turn done an ultrasound on her. And we would have known then. But she didn't. And that's why there's no evidence to show that it's the result of anything else, because there was no other test diving into why. She just had that test. That was it. And there were no tests after that. She could have done other tests to find out why. If she truly wanted to know why her HCG level does this, or why she can pop positive on pregnancy tests, and wanted to know the reasoning behind it, she could have done further investigation. She doesn't want to know, because she if she knows it, she can't use it. On November 14th, 2023, Laura had a gynecological visit with a provider at MomDoc, an OBGYN service provider. At the time, Laura was given 2 pregnancy tests, both which were negative. This means Laura is no longer pregnant as of mid-November 2023. Okay, you've already stated that. According to Dr. Medchill, the facts and the evidence in this case suggest Laura became pregnant on May 20th, 2023, that her pregnancy progressed for some period of time, and that the pregnancy ended with a spontaneous abortion, or SAB, at some point in or around late October or early November, or possibly sooner. Yeah, we still don't know. July, October, November, sometime. We still don't have a date. And I'm not buying it. You would know. If she was, it would have been around July. If she truly was pregnant, which I don't believe she was, July would have been her miscarry date, and she would have had no reason to file this. But she needed to keep the charade up. Let's see here. According to Dr. Medchill, although some miscarriages end with a woman expelling tissue from her body, this is not always the case, and it's not uncommon for a woman to have a miscarriage in which the fetus and other tissues, the placenta, etc., remain inside the mother's body and are absorbed into her body. But what is the likelihood of that? Like, what is the percentage on that? Is that one of those 1 in a million? Because she's 1 in a million on twin pregnancies. Medical miracle. She is 1 in a million on getting pregnant without intercourse. And now she's what, 1 in a million on miscarriages that are absorbed by her body. And that is part of the story that she stole from that other woman, the vanishing twin. So maybe one fetus could absorb 2 fetuses. I think the vanishing twin theory is a 1 in a million chance. Or just vanishing a single baby, period. Like, so she's just a medical miracle on multiple things. Like, they really should study her. Like, go check yourself in. Since you're this medical miracle, they can find a lot of things using you. Marvelous medical woman. The unique facts and circumstance of this case make it impossible to determine when precisely Laura's pregnancy ended via spontaneous abortion, except to say this happened sometime prior to November 14th, 2023. According to Dr. Medchill, the facts of this case do not support a claim that Laura was required to file a death certificate under Arizona law. This is due to the fact that in Arizona, a death certificate is required if gestational age at the time of fetal death occurs after 20 weeks, estimated gestational age, or weighs more than 350 grams, about 3/4 of a pound. And in Dr. Medchill's opinion, fetal death in this case occurred before 20 weeks and likely much earlier. Okay. So you have 2 conflicting people. You have the mom doc OBGYN who's saying October, November. And then you have Dr. Medchill who's saying before 20 weeks. That's 2 conflicting opinions. Sorry, I will put the mic further away. My bad. What are you going to do with that? The court finds Dr. Medchill's testimony credible and helpful. The court further finds, as a matter of fact, Laura was pregnant during the early stages of this case, but that her later pregnancy ended in a miscarriage at some point before November 2023. And due to the circumstance, Laura was not required to file a fetal death certificate. I don't think that the judge is going to find that as a fact. I just don't. There's too many things that happened in that time period. You missed all of October. You missed a bunch of sonogram stuff that you didn't put in this fact-finding thing because none of those are factual. That's probably why you didn't do it. It's a fact that she lied. It's a fact that she didn't have these medical records. None of them. Where did Dr. Higley come from? You didn't even address Dr. Higley in this. You didn't address Planned Parenthood in this. You have a lot of things missing. Due to the unique circumstance of this case, the court finds, as a matter of fact, it is impossible to determine the exact date of Laura's pregnancy ended, but that this determination is not necessary to resolve any issue in this case. No, I don't think we can find that as a fact. Yeah, he does like to ignore things. He can't find that as, I don't think the court can find that as a fact, that her due date is impossible. Because if Judge Mata does not believe that she was ever pregnant, she's not going to agree to the fact that she had a miscarriage and her pregnancy ended, because she's going to believe the pregnancy never started. So I don't know if that's a fact that she's going to be finding on 82. According to the docket in this case, of which the court may take judicial notice, Laura filed no further pleadings in the action after she learned she was no longer pregnant in or around early November 2023, until such time as Mr. Echard retained counsel, who first appeared in this case on December 12th, 2023. No. Mr. Echard retained counsel who first appeared. No. He ended up with counsel before that. I mean, it wasn't Woodnick. And it, well, okay, yes, for this case, it was December because the order of protection and order against harassment, that was a different case. I mean, they've merged them together now, I believe, but that was a different case. So, yes, in this case, it was like December. I was fixing to say no because he had representation and that order against harassment second hearing. Okay. Nope. I checked. All right. We can agree that he didn't have counsel at that point. All right. We can agree with that. On December 22nd, 2023, Laura retained counsel to represent her in this matter. And on December 28th, 2023, Laura's counsel filed a motion seeking to voluntarily dismiss the case with prejudice. On January 2nd, 2024, after Laura's motion for voluntary dismissal was filed, Clayton, through counsel, filed a motion for Rule 26 sanctions. That motion was later withdrawn, and as of the date of trial in this matter, there are no other pending motions or sanctions. Okay? The judge said, no, you're not getting to dismiss this case. So, yeah, she can motion for that, but the judge said, nope, we're going to see this case through because Clayton wanted to and for other reasons, I'm sure. But it's interesting that Laura knew in or around mid-November that she was no longer pregnant. And they said, okay, that was the 14th. So if we let's go to Schnitzel Ninja because he has facts. Okay, so yeah, it would have been after the November 2nd hearing. So they found out maybe December. I don't know if she told anybody or if she told Corey in November or December or as soon as she went to Mom Doc. I don't know if she told Corey at that time. And then there was January, she wanted to dismiss the case. So she went from mid-November knowing she wasn't pregnant to January before she was willing to voluntarily dismiss this case. Several months. And then, of course, we hear about it in the February 24th hearing that she states, she's no longer pregnant. And Corey was like, yeah, she miscarried. We just don't know when. And then they're like, no, we need to roll back the tapes because she said she saw these doctors on these days and she didn't. And judge can go back and see that. Yeah, none of his conclusions match reality. He definitely. I wouldn't say every woman, Deb. I would say 99%. Because there is that 1 in a million that don't, like the vanishing twin. But that woman was probably getting prenatal care regularly. So she would have found out at her monthly doctor's appointment, if not sooner. Just like she went to her doctor's appointments that she said she did, which we know she didn't now because of the HIPAA releases, that she would have found out about it and she would have known the exact date. But she could not do any of that stuff because she wasn't pregnant and she needed to continue this line. She started looking real, real bad around October, November. And Laura was like, oh, I'm not pregnant anymore. Timing is real suspicious. All right, now we're going to go to proposed conclusions of law. Sorry, I did not think this live was going to last this long, but, sometimes we sometimes we have to talk to our peoples. And I appreciate all y'all. Make sure y'all hit that like button. Subscribe if you haven't. I really appreciate it. We're going for 500 right now. We're getting closer, and then we can work on monetization and merch and all that fun stuff. Proposed conclusions of law. 1. Court finds as a matter of law that the establishment petition filed by Laura on August 1st, 2023 is moot as a result of her miscarriage, which occurred at an unknown time prior to November 14th, 2023. I don't know. Can we conclude that? Laura is no longer pregnant, and there is no other issue of paternity for the court to decide. Accordingly, Laura's petition is hereby dismissed as moot. Maybe. But that would be the judge saying that she thought she was pregnant. And if the judge does not agree that she was pregnant, I don't think the judge can come to that conclusion. We'll see. Be interesting to see how all these things turn out and what the ruling and opinion is on this. 3, to the extent Clayton has requested a judgment of non-paternity, the court finds that there is insufficient evidence to grant such relief. Well, I think 2 little to no fetal DNAs to me is enough. I know there was 3 tests, but we at least have 2 that were the same. I don't know how many would it take. Would he have spent that $725 10 times for them to be like, okay, we think there's no fetal DNA finally? Would it have been 5? Like, how many would it have taken? I would really like to know that. 4, Arizona law provides various ways in which paternity may be established and various presumptions that may apply in an establishment action. 5, among other things, ARS 25-814A2 provides a man is presumed to be the father of a child if genetic testing affirms at least 95% probability of paternity. But if we go back to the part that Woodnick left out, thanks to Nuttin Like Tea says, Rule 25-807DD, if the results of a genetic test indicate that the likelihood of the alleged father's paternity is 95% or greater, the alleged father is presumed to be the parent, which is what Gingras states. Now, the part that he left out, the child and the party opposing the establishment of the alleged father's paternity shall establish by clear and convincing evidence that the alleged father is not the father of the child. I think Clayton has done that. But, you know, I don't think that we can say that there was anything 95% of probable that Clayton was probably the father or not. I don't think that's been proved by clear and convincing evidence. I don't think anything about Clayton and a baby is clear and convincing. Per ARS 25-814C, a presumption of paternity is based on DNA testing, like all other presumptions under ARS 25-814A, may be rebutted only by clear and convincing evidence. Yes. And I think little to no fetal DNA is clear and convincing. Her lying about a bunch of stuff, clear and convincing. 7, by necessary implications, the court finds as a matter of law that in a dispute, paternity establishment action such as this, a judgment or finding of non-paternity requires a clear and convincing evidence to show that the alleged father is not the father. Such clear and convincing evidence may include genetic testing that excludes the alleged father to at least a 95% probability. 8, here, although DNA testing was performed, the results of those tests were inconclusive. Where did Ravgen say inconclusive? I heard them say ongoing or maybe inconclusive with the first one, and that's why they had them retest. But did they say after 2, 3 tests total, but 2 came back, or were they still saying it was inconclusive? Like they think they messed up the test twice and lost the test once. Ravgen, you're not looking too good. You're not making yourself look very good if you're saying that people have to continue to take these tests. I'm glad they reimbursed Clayton's money on that, though. So we only have, I don't think I've heard 3 tests that came back and said that. If there was, I've heard 2. I heard there was a 4th test, but I think the fourth test didn't happen. 3 said little to fetal DNA. Okay. So 2, 3 tests, I don't care what it is. It's insane. And if Ravgen is like, no, those are inconclusive. No, I don't think they are after that many tests. I'm sorry. Dave recently. Yeah, I knew the second one got lost. It's just crazy. Like, just none of this makes sense. I don't get where they're saying inconclusive. And we have the phone call. I don't know that we had the phone call with Clayton when he was told something, but Clayton's credibility isn't really doubted as much. But the phone call that we have with Laura on the phone with Ravgen, that was after the first test because she got pissed off that he went to Instagram and was like, little to no fetal DNA. And he was like, let's go, baby. I did cover that in my Echard series. That one was inconclusive, but I don't know that Ravgen continued to say inconclusive after multiple tests came back that way. I mean, it could have been Ravgen. It couldn't have been. They can verify that, though. They subpoena the records. So it's just her and her 1 in a million. 1 in a million. It was inconclusive. And then he actually there is DNA in there. We just can't find it. Another medical marvel. She is. Based on these inconclusive results and the lack of any other clear and convincing evidence, the court cannot determine as a matter of law that Clayton has met the burden of proving non-paternity by clear and convincing evidence. I disagree. I think we can come to a conclusion that Clayton is not the father of babies and that there was no babies based on paternity DNA. I think the paternity test also proved she was never pregnant. Like, she's got so many avenues that prove she wasn't, but she has no avenues that prove she was other than a pee sticks from her Banner Health patient portal. To the extent Clayton was, oh, wait. So, he's like, I don't think anybody can say that he wasn't the father because tests were inconclusive. I don't think we can find a fact or conclude that reality at all. 10, Clayton's request for a judgment of non-paternity is denied. 11, to the extent Clayton has asked the court to find that Laura lied about being pregnant, or that she made the whole thing up, or that she filed this action with any improper motives beyond establishing paternity, the court finds those allegations implicate civil claims and civil causes of actions such as defamation, abuse of process, and malicious prosecution, for which both parties would have a constitutional right to trial by jury. So, to the extent Clayton has asked the court to find that Laura lied about this, this action. So he's saying it would be improper to say that the court say this. I don't think so. Because she's the one who brought this pregnancy to this. I think it can be said here, and then they can go for defamation, abuse of process, because she definitely has abused the process. 10 years of this, definitely. All 4 guys could do a class action civil lawsuit against her. I don't know if 4 is enough for a class action lawsuit, but, Dave Neal could join in. Woodnick maybe could join in, Alexis Linval, like they could all join in. They just do a class action against her and her abuse of the process and defamation and malicious prosecution. But I think the judge has a right to be able to say this stuff. But Gingras wants to believe that no, she can't. 12, the court finds as a matter of law and pursuant to ARS 25801 that it lacks subject matter jurisdiction to adjudicate civil claims and causes of action between the parties other than matters of paternity. The court further finds as a matter of law that Laura did not engage in any unreasonable litigation conduct in the matter from the date the action was filed on August 1st until the date Laura moved to dismiss the case on December 28th, 2023. So she moved to dismiss it the 28th. She's known from mid-November. So she waited a whole month to do it. And in January, I think it was shut down. Yeah, it was in January that it was shut down. And they said, no, you're not dismissing this case. But she did not engage in unreasonable litigation conduct. Are you kidding me? How could you put that in here? Nobody's going to find that. Like, no. She has doctored medical evidence. She has lied about going and seeing doctors. She has messed with ultrasounds. So don't sit here and tell me she did not engage in any unreasonable litigation conduct. Her behavior is appalling. And the fact that you even have the audacity to put that number 13 statement in there is ridiculous. You are not credible, Gingras. God. Like, I cannot like lawyers. There are a lot of lawyers that I don't like. But you sit here and lie almost as much as she does, or your is omission. You omit things. You ignore facts. Yeah, he is so hung up on that Woodnick size of the hand thing. Like, that was what his tweeting was about yesterday. It's like, dude, come on. He lied? Oh, where is that? I have that. Let's see if I can play it.
Not pregnant at that time, and she lied.
Did that play? I've never done a clip, so I don't know if that played. But yeah, he lied. Yeah, I know he didn't see the subpoena for Mike, but he doesn't see a lot of things. Like, he's missed all of October apparently in this thing. Yeah, he plays dumb. He knows it's there. That, or he's drinking too much, or he's on substances himself. Allegedly. He probably isn't. I'm just kidding. Don't come for me. But you can't sit here and say that she hasn't done anything unreasonable. Yeah, no. Like, you are despicable. I despise some other lawyers. I don't like them. Like John Pryor. I do not like John Pryor. I am not. John Pryor was Daybell's attorney, Chad Daybell's attorney. I am not a fan of Jen Griffin and Poot from Murdoch. I think they have, they think women are stupid and we can't simply understand things, and that things are the way they should be and are, like they were in like the 50s and stuff. Like, women are just stupid and we couldn't possibly understand anything. Like, I don't like them. But I don't see them getting up here and just doing stuff like this. Gingras is below that. Gingras is scum. I don't like him. If I talked to him, I would be civil and respectful and polite. Unless he said something to me. But probably would just be like, okay, yeah, whatever. You can say what you want. But it's just, he's gross. Yeah, it is. And justice needs to come for all four of these guys. Let's move on because he thinks Laura hasn't done anything unreasonable in this case. Ugh, baffling. 14. The court further finds as a matter of law that to the extent Clayton incurred attorney fees on or after December 28th, those fees were incurred solely because Clayton objected to Laura's request to dismiss this action, and to the extent Clayton continued to incur fees after December 28th, 2023, those fees were not caused by any unreasonable litigation position taken by Laura. Okay. We'll go from August 1st to December 28th. And all Clayton's legal fees from that time period should be covered. I think it should still be covered past that because she continued to lie and submit fake evidence. She continues to lie. And if she would have just told the truth, Clayton wouldn't have any of these attorney fees. So I think she is the cause of all these attorney fees because he wants the truth. And she could have fixed this a long time ago by saying the truth. No, I don't think any of the previous lawyers lied. I don't think any of them lied. Because Corey was still able to say that he believed she was pregnant and all that. And it wasn't until after those HIPAA releases were signed that Corey left. So before any of that happened, and the deposition hadn't been done yet. So Corey Keith didn't even do the, he wasn't even there around the deposition. So I don't think any of the other attorneys, the previous attorneys, lied. I think when they found out that she lied and they said, nope, because they cannot go in there and legally or ethically say that she is pregnant when they in fact know that she is not. But Gingras doesn't seem to care, even though he stated, oh, if she lies, oh, but all the lies she's told she's fessed up to, so it doesn't count. But yeah, no unreasonable litigation conduct. Give me a break. He signed this on June 3rd, 2024. And there's Dingus, Doofus, Douche Canoe's signature. No, Doofus doesn't care. He's getting a paycheck. Exactly. I mean, he represents the scummiest of the scummiest. And I know that scummy people need attorneys too, but just because the people you represent are scummy don't mean that you need to be scummy too. All right. So that is the factual findings, conclusions of law. It'd be interesting to see what the judge is going to say about those things because I don't know that she's going to agree with many of those. So our quote for the day, our facts are true whether or not you believe them, by Neil deGrasse Tyson. This is my chance. This is my part in loud little ducky fashion that I kind of go into my mom soliloquy and things like that. At the end of the day, whether Laura wants to accept the facts, the truth, not her truth, whether she wants to believe them or not, they are facts. It is a fact that she lied. Is it a fact? It's a fact that she doctored things. Those are facts. There's so many facts that make her look awful. And it makes everything she has done and said questionable. Just because you don't like something that's true doesn't mean that it's not true. You know, facts don't care about your feelings. They just don't. Because a fact is a fact, no matter how you put it. It can be rude, it can be nice. Yeah. I personally, in my opinion, think that it is a fact that she pretended to be Chase J. Jones. And we went over that possibly criminal charges, and maybe they won't go after her for criminal charges on their own. It would be nice if they did, but it may take somebody actually filing charges and telling them that they want the state to press charges. They want to press charges on all these things. And it could be in Arizona and in California. But that is going to be it for me. And I don't know what video is going to come next. We have, I know a part 3 of Gillespie is going to be coming out. And then we'll probably go over the response. We'll probably go over the pretrial motions once they're actually submitted to the court and all of that. But that is going to be it for today. Like this video, share it, subscribe, turn those notification bells on so you know when I go live. You can follow me on Twitter, Loud Little Ducky. That's where I'll kind of share links and post when I'm going live. I will try to have them like pre on their thing, so it kind of says, oh, this day or this time she's going to go live. But sometimes I don't exactly know the times that I'm going to go live. But I will try to do my best to get y'all notified so you know. But I hope all of y'all have a fabulous evening. And I will see you next time. Bye. Let's see here in stream.